Call the meeting to order now.
Okay.
5:35 p.m. And we'll have the adoption of the agenda.
A motion to approve the agenda.
Second.
I guess there's no objections, right?
No objection.
Okay.
So we adopted the minutes from the June 21st, 2023 meeting. And now we'll have the approval of the minutes for this particular meeting.
I actually still have a correction on what's
Oh.
listed on the agenda. And I
Okay.
guess I probably should have done that when we adopted the agenda.
Oh, we're
But
not
it's
approving.
approved, yeah.
Okay, sorry.
But actually, what I did I didn't correct the date on the April 18th. It said I had actually seconded a motion for the February, for approval of the February minutes, and I was not at the February meeting, so I know I did not second that motion because I would have had no clue whether they were accurate or not.
Okay.
So it was really, yes, I did suggest a correction, but it wasn't to the date, it was to whoever seconded it. I did not second that motion. Because that was my first meeting, so.
We'll definitely make that correction.
Okay.
We don't have any old business. We'll start with the business discussion items, and that will be the election of the Gainesville Human Rights Board officers. And the chair and both vice chair positions are open at this particular moment.
What does NB mean? New business?
No backup. So if it's a backup on the agenda, it's like an attachment. And we don't have any attachments to the agenda. I think the chair kind of
What's-
conducts
Sorry, what's the point underneath election where it says description, employment discrimination?
that's just a general description that our office typically puts into under each case, we typically put some kind of description in there. So was just entered into there.
Oh, but it's not supposed to be.
Nah, I don't
Okay.
think
I was like, oh goodness, employment discrimination. Okay, so we need a chair and a vice chair. Both positions are open. And I'm assuming the people who are at the table right now are the ones eligible. Would anyone like to be chair? Would you like to be chair? I'll be chair.
Very good. That sounds good.
Awesome.
All in favor?
Aye.
Awesome.
So someone has to be vice chair.
Yes.
So would anyone like to be vice chair?
I'd be interested.
Yeah.
Got my
Seconded?
vote.
Yeah, there you go.
Here we go. Perfect.
Okay.
All right, do we have to do official motions for these two things, or?
I think we just did, that was on the record.
Okay.
Yeah. Everybody was unanimous. Congratulations.
Maybe.
So we'll move to the next item, which is the Wayne Gordon case, and that's EOE 2022-39. And this is an employment discrimination case. So Chair, the Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning complaint of discrimination EOE-2022-38. We have processed the complaint as required by Chapter 8 of the City's Code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance, Section 8-48, Subsection A, Subsection 1. We are now ready to report the results of our findings concerning complaint of discrimination EO-E-2022-38.
Members of the board, thank you for your presence and participation. You have each received a copy of the final investigative report for complaint EO-E-2022-38 and have had time to review the findings. I will now summarize the finding as it relates to this case. The complainant stated that on September 2nd, 2022, Dennis Ham, DJ manager, White, terminated his employment due to a sexual battery charge, which occurred in 2006. Complainant stated he was not convicted of the alleged charge. Complainant stated his employment as a lawn worker with Florida Greenkeepers in August 2022. Complainant started his employment as a lawn worker with Florida Greenkeepers in August 2022. Complainant stated the termination occurred despite the owner, Derek Shanahan, White, being aware of his record upon hire. On August 29, 2022, Greg Brunick, White, supervisor, said to the complainant, quote, "I never worked with a black man before," end of quote. On August 30th, 2022, Brunick also said, quote, "There is a bunch of monkeys in the truck," end of quote. Brunick then laughed. Complainant was in the truck when Brunick allegedly made this statement. Complainant reported the incident on August 30th, 2022 to Ham, who instructed complainant not to mention it to anyone. Respondent's position. Respondent stated complainant was not terminated because of his race nor retaliated against for reporting discriminatory comments. Respondent denied all allegations attributed to Brunick. Respondent stated the complainant was terminated for several misdemeanor and felony charges that were not disclosed on the employment application form. Summary of investigation findings. Race. To establish a prima facie case for race discrimination, the complainant must show 1, that he is a member of a protected class, 2, that he was performing at a satisfactory level, 3, he was subjected to a negative employment personnel decisions or otherwise discipline, 4, he was subjected to a negative employment/personnel decision because of his race. Complainant is a member of a protected class based on his race, black. Therefore, the first element was met. Regarding the second element, there is no evidence complainant was not performing at a satisfactory level, and the company did not assert that complainant had performance deficiencies. Therefore, the second element was met. Regarding the third element, complainant was subjected to a negative employment decision or discipline when Brunick made the negative comment and when complainant was terminated. Therefore, the third element was met. Concerning the fourth element, there is no evidence complainant was subjected to a negative personnel action because of his race. Regarding the allegation attributed to Brunick, Ham immediately investigated the comment as soon as it was reported. Witnesses and Brunick denied the August 29, 2022 and August 30, 2022 allegation that Brunick said he, quote, "never worked with a black man before," end of quote. Regarding the three monkeys in the truck comment, witnesses also stated that Brunick was making a point that three crew members were sitting in the truck, not working at the time. This statement is about an old television show about three monkeys, not complainant's race. Brunick had made similar comments in the past when complainant was not present. Also, there is no evidence Brunick attempted to run over the complainant. In his defense, respondent articulated that the stated reason was not a pretext for discrimination. Instead, complainant was terminated for failing to disclose a felony record in the application form, even though the application specifically asked, quote, "Have you ever been convicted of a felony?" End of quote. The designation for this record shows complainant as a sexual offender predator, quote, end quote. Respondents stressed that most of its lawn care jobs are performed on school and church premises, so it is important to have accurate background information before assigning crew members to a job. Therefore, there is evidence to support that the respondent's stated reasons was a legitimate non-discriminatory reason for termination. Therefore, as the fourth element was not met, the analysis ends. Retaliation. To establish a prima facie case for retaliation, complainant must show that 1, he engaged in a protected activity. Number 2, the employer took adverse employment action against him. 3, and there was a causal connection between the protected activity and the adverse employment action. The investigation shows complainant engaged in a protected activity when he reported a racially discriminatory statement to a supervisor in August 2022 and filed a complaint of employment discrimination on September 27, 2022. Also, Ham confirmed during a one-on-one interview that complainant reported to management the racial comment that is attributed to Brunick. Therefore, the first element was met. Regarding the second element, the company took adverse action against complainant when it terminated his employment. Therefore, the second element was met. Regarding the third element, there is no causal connection between the protected activity and the termination. Respondent has provided evidence to support his position the termination was not a pretext for an adverse action. Instead, respondent found out about complainant's criminal history, sexual offender / predator on September 2nd, 2022, and terminated complainant on September 2nd, 2022. Respondent stressed that the complainant was terminated for failing to disclose a felony record in his application. The designation for this record shows complainant as a sexual offender / predator. Therefore, as there is no causal connection between the protected activity and the adverse action, the analysis ends. Therefore, based on the foregoing, there is no reasonable cause to believe the respondent violated the City of Gainesville Code of Ordinance Section 8-48A(1).
As indicated in our written report, we have determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion to, by a 3/5 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record. Chair, as required, we have provided the board with evidence concerning our investigation for complaint of discrimination EO-E 2022-38. You must now decide based on that investigation.
Members of the board, we've had the opportunity to read the investigative report concerning complaint of discrimination EO-E 2022-38 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? Any questions from board members should be directed to the chair. Yes.
So I may have not understood something I've said, but did we actually confirm that they did receive, that he is a sexual offender and he does have the felony charges?
Correct.
That was all confirmed?
Yes.
Okay, and that call was made? All right, that
Yes.
was.
I have the record of that.
Great, thank you. That sort of ends my question.
I think from over here.
No more questions. Do we have any parties of interest from either the complainant or respondent side with us? All right, board, I think we're now ready to vote. Remember that we may only consider the evidence of record. The Equal Opportunity Director has determined that there is not sufficient information that would lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred, or you should vote nay if you believe that further investigation is deemed necessary. If so, we shall specify the areas of further investigation if, by a 3/4 majority vote, we deem such is necessary. So I make a motion. Can I make a motion?
No.
I can't make a motion.
Chair Forbes.
They just ask for a motion from the table, either way.
Chair Forbes. I move to accept the Office of Equity and Inclusion's report.
Is that seconded? I heard a second. All in favor?
Aye.
Aye.
All opposed? All right, the board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
The board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination EO-E-2022-38. So the final case that we have on the business discussion item is Martha Miller, and that's EO-E-2023-04. Chair, their Equity and Inclusion Office has provided the members of the Human Rights Board a written report concerning complaint of discrimination EO-E-2023-04. We have processed the complaint as required by Chapter 8 of the City's Code. We are here today to report our findings as to whether reasonable cause exists to believe that an unlawful discriminatory practice has occurred in accordance with the City of Gainesville Code of Ordinance, Section 8-48-subsection A, subsection 1. We are now ready to report the results of our findings concerning complaint of discrimination EO-E-2023-04.
Members of the board, thank you for your presence again and for your participation. We have each reviewed. You have each received a copy of the final investigative report for complaint EO-E-2023-04, and I've had time to review the findings. I will now summarize the findings as it relates to this case. Complainant's allegations. Complainant was subjected to non-sexual harassment, name-calling by Tanisha McNabb, and forced to resign as a kitchen aide on June 26, 2022. Complainant was instructed by McNabb to stop performing a task that was assigned by Shalivia Head, food service manager. Complainant reminded McNabb that she was not her supervisor, but McNabb insisted that she was her supervisor and called her the B word and threatened to hurt her while at work. Complainant alleges that McNabb and Head never made an effort to communicate effectively with her, even though McNabb and Head are aware of her disability being hearing impaired. Respondent's position. On or about June 11, 2022, Ms. Head, food service manager, received notification on her day off of a verbal altercation between complainant and McNabb, who also reports to Ms. Head. The complainant and Ms. McNabb are peers who do not have supervisory responsibility over the other. They work together at times on the same Saturday shift at the terrace. Because of this argument, Ms. Head personally came to the terrace to deal with the situation. Ms. Head is not aware of complainants having a disability, nor does Ms. Head have any knowledge that complainant ever requested an accommodation for such alleged hearing issues. To resolve the situation, Ms. Head spoke with complainant and Ms. McNabb, calmed both women down, and they apologized to each other. Ms. Head did not issue any discipline to complainant and Ms. McNabb for the verbal altercation. After this incident, complainant and Ms. McNabb were able to work together on their Saturday shifts at the terrace without any further incident. On October 11, 2022, Ms. Head received a text message from complainant stating that her work schedule at the plaza was interfering with her schedule at the terrace, and she had to provide her 2 weeks' notice. On October 14, 2022, complainant texted Ms. Head that, due to her husband's illness, she was unable to work October 15. Complainant did not return to work after exchanging texts with Ms. Head on October 14. The company accepted complainant's voluntary resignation. Summary of investigation findings. To establish a prima facie case of discrimination based on being regarded as individual with a disability, complainant must show that 1, she has a physical impairment that substantially limits one or major life activity, or has a record of such an impairment, or is regarded as having such an impairment. 2, she is qualified to perform the essential function of the job, either with or without reasonable accommodation. And 3, she suffered an adverse employment action because of that disability. The first element was not met, as complainant did not provide the respondent with proof to show that the company regarded the complainant as an individual with a disability. Also, the complainant did not provide medical documentation to support her claim of disability. Regarding whether the company knew or should have known of said disability, evidence showed that complainant informed the food service manager of her hearing impairment during her visit to the job site to settle a dispute between the complainant and McNabb. There is no proof that McNabb nor the complainant requested reasonable accommodation. However, text messages submitted by complainant shows the complainant had another job during her employment with the company. As such, complainant resigned due to a scheduling conflict and personal medical reasons involving a family member. Based on this information, there is no proof respondent knew or should have known of the purported disability before resignation. Therefore, as the first element was not met, the analysis ends. Therefore, based on the foregoing, there is no reasonable cause to believe that respondent violated the City of Gainesville Code of Ordinance, Section 8-4, subsection A, subsection 1.
As indicated in our written report, we have determined that there is not sufficient information that will lead an impartial observer to believe that a discriminatory practice has occurred. If you do not believe that there is reasonable cause to believe that a discriminatory practice has occurred, the Equal Opportunity Director must dismiss the complaint. You also have the discretion to, by a 3/4 majority vote, order such further investigation as deemed necessary. Your decision should be based on the evidence of record, Chair, as required, we have provided the board with evidence concerning our investigation of complaint of discrimination EO-E-2023-04. You must now decide based on that investigation.
Members of the board, you have had the opportunity to read the investigative report concerning complaint of discrimination EO-E-2023-04 and heard the summary of that report provided by the compliance investigator. What questions, if any, do you have concerning the report? Any questions from board members should be directed to the chair. No questions? Parties of interest, either on the complainant or respondent side, would you like to speak?
Ms. Miller?
Yes.
This is your opportunity to speak if you'd like to.
I couldn't hear you. Speak up here because I can't hear you back here because I can't hear out of my right ear.
Does someone have a timer?
Yeah, can we get 3 minutes on the clock?
So you have 3 minutes to communicate your story, or whatever you'd like to tell us.
My story is that I verbally told him when I started, and Ms. Head was not the first kitchen manager, that I cannot hear out of my right ear. Tynesha McNabb had a consistent hostile work environment to anybody with a disability. And as for not verifying it, I have no idea how to do that. Nobody has ever told me how to do it. All I was told was get a note from the doctor. I went to the doctor and said, hey, I actually talked to receptionist. I said, hey, I need a note that I can't hear out of my ear. I don't know who you sent the note to. And she said, we don't do that here. So it's a little frustrating for me, and it's not you guys' fault where it's like, you must verify it, or you must, well, how do you verify it? That's like, it's like looking for a unicorn to me. That's just a complaint, and it has nothing to do with this, and I understand how I didn't provide the documentation, but I did not know how to get the documentation or what was needed. And when I asked certain people I was supposed to, they were like, huh, no, we don't do that. But that's the way it is. But Tynesha McNabb is very mean.
Are we allowed to ask questions after they've, given their comment?
To the investigator or to the,
To ask just about the case.
yeah, thanks.
Okay, just curious. Alright, a couple things just
I think
I'll let the
on the
respondents speak.
phone.
Yes, right.
All right, thank
Mr.
you,
Ford.
Ms. Miller.
Thank you very much.
All right, so now can we put 3 minutes on the clock for the other party? And now respondent,
Mr.
you
Ford.
can start. Thank you. Can they hear
Good
me?
afternoon, my name is Senator Ford, I'm Assistant General Counsel for Next Level, responding to this matter. I don't have anything further to add. We concur with the investigative report and the findings that there is no evidence of discrimination here. Simply put, the complainant, Ms. Miller here, voluntarily resigned her appointment to take another job due to scheduling hours on that other job's end, in addition to what we allegedly personal and family medical issues on her end. So we concur with the investigative report's findings, and we just thank you for your time.
All right, thank you.
Thank you.
All right, are there more questions from the board now?
I just have a couple. So I guess my biggest thing just comes down to obviously the voluntary resignation aspect. There was clearly a reason that was provided just by the respondent recently. Was that provided to the investigators as well of that reason? Is there documentation of that reason?
I think the reason was actually provided by the complaint.
The reason, for voluntary resignation?
You're talking about the text?
Yeah, because that's my thing is I want to know what led to the voluntary resignation and where is it recorded? What is its record?
The voluntary resignation is due to scheduling conflict and personal family issues, illness.
And so my next question then is there a record of that that the investigators received?
You send a text.
Okay, perfect. That's all I needed to know. I just want to make sure that was clear.
And then right here, the text messages were submitted by the complainant. So these text messages were submitted by the complainant.
Gotcha.
Any other questions from the board?
Yeah, I have a question. So I'm looking at this first element, and so is there like a conclusive like thing of when the complaint like does it report address like when the complainant like does it address when the complainant initially verbally informs the respondent of their disability? Or
The respondent want to answer that? Are you asking me?
it was just about the report.
What page are you on, Maya?
I'm looking at I should probably not look at this. It was on 2 of 4 of the summary, but maybe it's further back.
You probably have to answer that.
I mean, what page are we talking about? I'm sorry.
She's just referring to the first element.
For the first element? I'm sorry, what do you need to know? I'm sorry.
I guess when was the, cause it says they didn't provide medical documentation, but like, do we know when the complaint, like when did the complainant like verbally tell the supervisor or, like their hearing impairment, was that in the report?
I have no record of that. The only time the respondent was aware when Ms. Head visited to resolve a dispute between the complainant and Ms. McMahon.
Oh, okay.
And there was no record specifically of, sorry, did you have another question?
No.
Okay. Is there like no record from the respondents and that they received documentation that there was a disability?
During our employment, no.
None, and there was no, because I know that the element is kind of like or, like it has a lot of like options to it.
But Ms. Head was aware when she visited the premises to resolve the conflict between the two parties.
Yeah, it's just more so, like, I understand the fact that there was no record, but obviously, like, if she does have a hearing issue that is affecting, like, you know, one or more major life activities, I mean, wouldn't that element be met? I'm just confused as to why that element wasn't fulfilled. Because it says, like, or this, like, it's seeming as if it's, like, either or would have to be fulfilled in order for that element to be met, and I'm just, like, wondering why that wasn't deemed fulfilled by the investigators, at least.
I mean, I have absolutely no record that of any disability.
There was nothing submitted.
Prior to that, but the company was made aware of a hearing impairment when Ms. Hay visited the premises on a day off to resolve the conflict. So the issue is, prior to that, did she notify the company of her impairment? And there's no record of that. Now, I'm not disputing whether she has a disability or not, but the issue is, did the company knew? Or did they know?
Yeah,
Or they should have known.
and that's like where like I'm not necessarily, it's just more so, I'm just trying to understand, like, from a more practical side, just so that in the future, when these kind of circumstances come up, like why certain elements weren't met, when it kind of has this very like, it's either this circumstance is fulfilled or this circumstance is fulfilled or this one, that would lead to it be fulfilled. Because it says here, you know, number one, she has a physical impairment that substantially limits one or more life activities, or has a record of such impairment, or is regarded as having such an impairment. I mean,
Those are kind of just the various ways that an individual can show that they have a disability. So, you know, if they have some kind of documentation, or, if they, I guess, if it's kind of obvious at some point. But those are just the different methods of how an individual can establish that they have a disability to begin with.
I think it's, sorry.
Oh, go ahead.
I think it's like in some of the cases where they say the first element must be that they are a member of a protected class. And it's like the person was black, so they are part of a protected racial class, and then we move on. I think here, they're treating hearing impairment as sort of like an invisible disability. It's not like if you were missing a limb and it, like an obvious knowing of it. So the company should
Very
know that you have a
conspicuous.
disability. This is one of the ones where it's more unseen. And so they're saying it was someone's job to document it or report it. Because I hear what you're saying, it does substantially limit one or more of your life activities, but it's not a seen disability.
Okay,
Is where I think maybe your confusion is why element 1 was not met.
perfect, awesome. That clarifies
Is that
the part.
right? Is that
Yeah,
Yeah.
and
So
pretty
then-
much it wasn't, so pretty much from my understanding, the complainant did not establish either of these three methods with the respondent to establish that she had some sort of disability.
Okay,
From,
perfect. Nothing further.
Sir, can we help you? Are you looking for a meeting?
I was looking for the Police Advisory Council.
Oh, I think you might want to check the commission, and if not, the security officer there can let you know. He has the calendar of it. Thank you.
Any other questions from the board? All right, I think we're now ready to vote. A reminder that you may only consider the evidence of record. The Equal Opportunity Director has determined that there is not sufficient information that will lead an impartial observer to believe that a discriminatory practice has occurred. You should vote aye if you agree that there is no reasonable cause to believe that a discriminatory practice has occurred, or you should vote nay if you believe that further investigation is deemed necessary. The board shall specify the areas of further investigation if by a 3/4 majority vote we deem such further investigation is necessary. Can I get a motion?
I have a motion, Chair Forbes. I move to accept the report delivered by the Office of Equity and Inclusion.
I second that motion.
All in favor?
Aye.
All opposed? The board has voted that there is no reasonable cause to believe that a discriminatory practice has occurred.
the board has determined that there is no reasonable cause to believe that a discriminatory practice has occurred, and I shall dismiss the complaint. This concludes today's business as it relates to complaint of discrimination EO-E-2023-04. The next item is public comment. Is there any public comment? Any member comment for item H?
I'll speak briefly. So I'm happy to be back on for another term. I wanted to kind of just share a couple of the ideas and focuses I wanted to bring into this term. And if any of you were interested in those, obviously during the next board meeting, we can have that dialogue in the member comment section or through adding it onto the agenda. But I was looking to try to work to develop a kind of promotional campaign to help ensure that like all our constituents were aware of like OEI services and programs, kind of doing a little bit more of seeing where those areas are kind of not being covered and seeing where we can help to make sure that, the Office of Equity and Inclusion is more visible and that folks know that there's this service that they can reach out to. I know that there's obviously some work already being done and I see it like on the day-to-day, but I want to see like where it's not and help fix that. Another piece of that is also just coordinating with you all and also the OEI staff to help address some areas that may be lacking in accommodations for ADA compliance and working with other city officials to see where we can try to help out with that. And then the last piece that I kind of touched on within kind of what in my public comment was reaching out to OEI staff more about looking at the viability existence in our like efficacy certification programs that could be geared towards different businesses or organizations that can help them to promote more of an inclusive culture within their workplace and kind of preventing, discriminatory acts that we see within this board. Kind of helping to be more preventative and more proactive in that approach. And so if like any of those are interesting to you all, I'd love to talk with you all maybe sometime after this meeting or at the next meeting. But I'm looking forward to these next couple of years and looking forward to serving with you all.
Oh, I also have a comment. I guess I would like to know for future cases, like what does having an obvious disability really mean? Because, like, I guess you could see something different but not know it's because of a disability, so I think it's a bit of a gray area, and I think that's something that should be clarified a little bit.
So, I mean, I could give you so the reason that the ADA prima facie elements are stated the way they do is because they apply to two different types of litigation or claims that can arise. So one is your true disability discrimination, where someone appears at your office and say they're in a wheelchair, and then their supervisor makes slurs and comments, oh, you can't come to this meeting because, things like that, and then they terminate them. So that would be, they should have known, or they treated them as one who has a disability. Where you get to the documentation side, and when someone brings a disability claim before the court, they do have to show medical proof that they have a disability that actually limits one of their major life activities. And that major life activity affects your work as well. So the more common type of ADA claim is that you didn't reasonably accommodate the person. So the wheelchair person comes into your establishment, you hire them, they clearly have a disability, no one's disputing that they're using a wheelchair, and they come to you and they say, I can't use the restroom here, and I can't work if I can't use the restroom. And then the employer ignores all that, does not engage in any type of interactive process to find an option for this employee, and then the employee has to quit his employment or her employment because they can't work there. And so that would be an ADA reasonable accommodation claim. And again, if you're filing a claim, the first step you would have to do in a court of law is provide medical documentation that you had this disability that limited one of your major life activities that keeps you from working with or without a reasonable accommodation. So that's ADA 101.
Does that help, Maya, or would something further be needed for these sorts of cases where the employment discrimination is based on ability?
Yeah, I think it helps, I guess. I think it's a step in the right direction. There might be more needed though, I'm not sure.
Yeah, so like I kind of was stating earlier, when an individual is trying to establish that they have a disability, the courts allow them to prove or show that in those three different ways. So either they have a record of it, it's kind of an obvious disability, or their employer regarded them as having a disability, meaning they kind of, called them or associated them with a certain disability. So if the complainant is able to show with either one of those three ways that they have a disability, then that will establish the first element. From my experience, most individuals establish that by way of a medical documentation, which that would be the second way that it can be shown.
I have no comments.
Nothing over here. Thank y'all for hearing me out.
Yeah.
Sure.
And we'll look into your recommendations and see if that's something we can work on.
So if we could, before we take any motion to adjourn, we need to take roll call so we can establish who is here and who is not here because of our attendance procedures.
No.
And it also will just establish the board.
Do I need to do that?
Sure. I mean, I think you just, everybody state starting with Jonathan, state for the record your name, and then we just go around the table and then we'll take care of it.
Yeah. Jonathan Stevens, Vice Chair.
Maya Rothstone.
Christina Palacio.
To Glenn Forbes.
And everybody else is absent today.
to the next item, item I. The next meeting date will be September 20th, 2022.
23.
And then we'll go to the next item, adjournment.
Do I have a motion to adjourn today's meeting?
So moved.
Second.
All in favor?
Aye.
All opposed? I think the meeting adjourned.